Now then, it's Burnsy, and welcome to our regular Curiosity podcast, the CuriosityCast. Every episode we take questions asked by members of the public in Hull and try to get them the best answers from the very best brains in the city. Not all questions are about Hull, they can be about whatever you want to discover. For this episode, we're going a bit different. It's time to get legal. We've received a few questions regarding specific areas of law, but rather me and producer Dave taking wild guesses at the answers, we've pulled in the experts. Laura Fahy and Emma Hamilton are solicitors for the esteemed Hull firm of Wilkin Chapman Rollits, with specific briefs in wills, estates and tax planning. So to make best use of their skills, we're concentrating on areas such as will, power of attorney and probate. We should say that Laura and Emma are only able to offer guidance in broad general terms, and any specific legal advice about your personal situation, you should seek out your own solicitor. Laura, Emma, welcome to the Curiosity Cast. First up, Rollits is a name that's long been well known in Hull. Is the Wilkin Chapman edition caused by a merger or similar? Is that fairly recent?
We are almost at the anniversary, actually, of the merger, which happened last year on the 1st of April.
All right.
So Wilkin Chapman had quite an established background in the South Bank, Rollits in the North Bank, and by coming together, we're taking over the place by the sounds of it.
Right. So there'll be cake and champagne fairly soon then to celebrate.
I hope so.
Yeah,
I don't think we're in charge of it, but I hope
Bonuses all round. Just mention you've been on the Curiosity Cast. There's bound to be a massive bonus for that. Let's get straight to the questions. Producer Dave will interject at various points of the proceedings. This from Anna in HU5, the Avenues. I have elderly parents not in the best of health, and someone mentioned that seeking power of attorney is a good idea. Is it? Who wants to take that?
Yeah, I think
This
definitely.
is Laura?
Yeah, definitely a good idea to put powers of attorney in place. I mean, the Law Society recommends anyone over the age of 18 looks at putting one in. So there's two types. There's one for finance and one for health. And it's just a case of looking at putting someone in place that can assist you whilst you're capable, and also in the event you lose capacity, that you trust,
Right.
essentially.
Essentially, what is it? Give us the Janet and John version for me and Dave, really.
So they're quite a formal document that somebody puts in place, appointing somebody to step into their shoes in an event where they're unable to make decisions. So the finance one covers accessing bank accounts, speaking to pension companies, selling property, particularly relevant to somebody who's not very mobile and can't get to a solicitor's office to sign forms, or loss of hearing, can't ring somebody. So it's quite useful for the finance to deal with that. And then the health side of things, again, somebody's stepping into your shoes. So if you can't make decisions about treatment, care, where you're going to go, types of care, really serious decisions about operations, etc., then somebody's there already in place to make that decision for you and just make everything a little bit easier, a bit smoother.
Is this something you need a reasonable lead time and conversations with the person who you're going to have power of attorney over?
So
I can imagine these are quite difficult dynamics.
So it happens the other way around. It has
Right.
to be the person who wants the power of attorney for their decisions. It's their choice to put it in place. So it's not something a child can do on behalf of a parent. It has to be the parent making the decision. So the conversation
So it would
happens.
be Anna's parents.
It
who
would
get
be,
in touch.
yeah.
Right.
And they have to have capacity at the point they're doing the documents. or
What happens
preparing
if
the
they've not
documents.
got capacity then and they need somebody to look after them in terms of making those sort of decisions?
Well, that would be then, if you haven't got capacity to make a power of attorney, it would be for family members to apply to the Court of Protection to look at getting a court order
That
in
gets
place.
very complicated
Yeah,
then.
so you're looking at, rather than maybe timescales of 2 to 3 months with a power of attorney and getting that registered and ready to go, can be 9 or 10 months waiting for permission to deal with the affairs.
It can be even longer.
Yeah.
I've waited 18 months to 2 years for deputyship orders on occasions.
And if people are ill or old, 18 months is a lifetime, isn't it?
Yeah.
And we've had people where we get the deputyship orders in and, you know, things have happened that treatment or medical issues have progressed, and actually they don't survive very long after it. So that 18 months, nothing's been able to happen, and actually the deputyship order's almost
So this
useless.
is something really you should think about before you get too old, you should think about how am I going to be looked after when I'm older, when I'm in trouble.
Yes, yeah, definitely.
And ask your kids, should it be your kids, should it be a family member, can it be, if you've not got kids, can it be anybody?
I think it's a case of it could be a friend. It's someone really essentially in terms of your finances and your well-being. It's someone that you would trust to act in your best interests, really. So it's taking the time to make the right decision.
Because you're putting a lot of trust in them, aren't you?
Yeah. And they're not a straightforward document because there is complexities, there is duties and powers in place. So there's safeguards there to make sure that the right person has, the knowledge of what they've got to do. There's going to be a risk because people do abuse it, but currently with nothing in place, potentially you've got even more open to abuse.
Well, you're not even safe from yourself in some ways.
No, not at all.
I've got to say, we did it for my parents a few years ago. Me and my sister, a power of attorney. And when we lost my mum, my dad said he wouldn't have got through it without the power of attorney being in place, because we were able to handle so much of it that he said I wouldn't have been able to do it if he hadn't. So he was delighted that we did it. And it wasn't that complicated a thing to do or expensive, really.
Lots of people, I think, view it as something where it's only to be thought about at the point when you're losing capacity, but actually it can have much wider uses. Like you say, we've had loads of clients who ask their children to get involved because the situation is just overwhelming. They've still got capacity, but actually they really want the help. And having that document already there, ready to use, allows them to step in immediately. And it can just make, particularly where there's been a death of one party, the other party can, just continue to manage doing things a lot easier with that knowledge that they don't have to take it all on themselves.
When does it come into effect then? Does it come into effect as soon as you've done it? Or you say, well, I think I've got 5 years before my head becomes a shed sort of stuff, and then is
that a common phrase?
I don't think it's a legal phrase.
No, it's good though.
If it is, then maybe I've got a future in the law. Somehow I doubt it. But before I sort of lose capacity, can I future-proof it? I might not want to give them capacity now or control power of attorney now. Do you see what I'm driving at?
So for the document to be actually valid, it needs to be signed by everyone. So by you making the document and by your attorneys and dated. But actually before your attorneys to act under it, it needs to be registered with the Office of the Public Guardian, so they oversee it. So it's once that's registered that it can be used. But obviously, whilst you've got capacity and you're able to manage your finances, it's up to you to make that decision about whether your attorneys help you or not.
So you continue to be in control.
Yeah,
it's not a kind of sign on here and everything gets handed across, not at all.
Suddenly my kids have sold a house. I get a postcard from a yacht in the south of France. Loving it, Dad. Sorry, my kids aren't like that, but at least I don't think they are. I've not signed over power of attorney yet, so you never know. Are people having these conversations? Do you see an increasing number of people coming to you and saying, I'd like to do power of attorney? Or is it still not enough people doing it?
We're quite proactive in asking the question, even if it is at an early stage when you've got a young couple with a young family. We still mention it so that it's almost been drip fed up to the point where they get it in place. Maybe when they feel like it's needed a little bit more or they're a little bit older, but at least it's been mentioned. It tends to also then prompt them thinking about their own parents. I personally think there has been an increase since COVID. Yeah. Because I think that in itself made everybody realise that this, capacity is not necessarily an old person thing, and it can actually affect everybody. And I think that panicked some people. So there was a lot of uptake, I think, and a lot more media around it as well.
I don't want to scare anybody, but what are the downsides of not doing it?
Well, you end up in your shed, and nobody's in charge of anything. You're a rudderless shed
with a head like a shed.
Yes. I think that's the danger, isn't it? Is if you lose capacity in some way, and it doesn't have to be dementia or anything like that. You could be hit by a bus, looking on the bright side. But it's in any way you lose capacity or unable to look after yourself. There's somebody who can just step into your shoes, and it's about looking after your wishes, isn't it? It's about making sure your wishes are kept, not the legalities of it, but just anything in terms of wills, monies. Funeral arrangements are all in place with somebody else. I think you're right. You do need a lot of conversation. We had a lot of conversation with parents beforehand. But then when we did it, it was actually a really pain-free process. There's just a few cognitive questions, isn't there? And that's about it, really. It's relatively simple to do. You mentioned cost earlier. Roughly, how much does this sort of process cost? People be interested.
We tend to deal with it on a fixed fee basis.
Right.
Because they're all separate documents, we're essentially charging the client per document. So there's a starting fee because the most of the work is done for the first document anyway, and then there's an add-on for every additional one. So, for instance, a couple doing both documents, we would charge £1,700 plus VAT, and then there's a registration fee per document, which is £92 currently per document.
So you've got security and everything like that for well under £2,000 anyway, yeah. So you've done it, sorted, and away you go.
Yeah, and there is no time scale on them, so you do it now. Unless you have a reason to change it, revoke it in the future, then it lasts until your death.
And I found it sorts a lot of stuff out that could have turned into a lot of arguments and mess.
Right.
You know.
Well, you were involved.
Well, it did. Me and my siblings, there could have been bloodbath.
Blimey. Let's get back to the serious stuff. Claire in Hessel, can I have power of attorney over a parent and still be the executor of their will, or executor of, not executor? you wouldn't get any money if you were the executor, would you? The judge would see to that. You'd be doing porridge.
Surrounding that.
Yeah. I used to be able to read at one point.
It means the same thing, though, doesn't it? It's just said differently.
Or can I only be one or the other?
Well, no, there's nothing stopping you being an attorney and an executor of someone's will. It's just they're different documents. So, like we've said, the lasting power of attorney is now while someone's alive, whereas the will comes into effect when they die. It's just a case of deciding whether someone is appropriate for both roles, really, because you might have named someone as an attorney for a health power of attorney because they're more inclined to be able to make decisions about where you live, your day-to-day routine and your medical treatment, whereas that person might not necessarily be as good with paperwork. So with an executor, you're looking at someone who's going to be happy to look at gathering together all your finances and calculating the value of your estate, and there might be inheritance tax involved. So it's just thinking about who's best suited for those roles. I guess the question's
based on, is there a conflict of interest, really, in there?
Yeah, and I don't think...
It's like the start of a night gift for the Christian.
Yeah, and I think...
Scene one in the solicitor's office.
And I think, I suppose, the thing is that when you're an attorney, you're handling that person's money and you're accountable for dealing with it. So if you're their executor, in a way, you've already got the information to hand. You are very familiar with their affairs, so it's sort of a natural carry-on from it.
I think the concern about being in conflict of interest would only ever come into effect if you're appointing people that you don't actually trust to deal with it in the first place, which we would absolutely never suggest you do.
Yeah.
Don't appoint anyone evil. It's as simple as that, isn't it? You watch yourself, Dave.
That's quite the extreme. I'm not sure it's as obvious between families at times.
You've got all this rapidly approaching.
Thanks. I'll try and make the end of this episode of the CuriosityCast. If I don't, my estate will still bill you.
I've noticed you normally flag around 16 minutes in. We're nearly there now.
We should say this is the latest episode of the CuriosityCast you're listening to. God bless you for that. Thank you very much for your company. Our guests today are Laura Fahey and Emma Hamilton, solicitors for Hull firm of Wilkin Chapman Rollits, well, Hull and Grimsby, south of the river. We've established that already. This from Tracy in HU3, which is on Anlaby Road. My mum passed away recently, and though she left a fairly comprehensive will, some pieces of her estate ended up in probate. Why does this happen? Maybe we should explain first what probate is. Don't all rush at once.
I think that there seems to be a bit of a misconception as to what probate generally is. We have lots of clients who don't necessarily understand it. So the process of obtaining a grant of probate is essentially applying to the court with what we either think is the final will or with the legal circumstances of the family to ask for formal authority from the court to either deal with the estate in accordance with the will or in accordance with the law if there isn't a will. So it's a court order which gives somebody authority to actually deal with the assets. Now,
and every situation needs that?
No.
Oh, right.
No. So every bank, financial institution, every company has its own rules. There is no set standard. So somebody like the land registry, if there is a property in somebody's name, they will insist on a grant of probate being obtained before they will allow any transfers of the property to happen. But certain banks have a threshold that's quite high. So if you had a bank account with maybe £30,000 in it, as long as you sign the form, show them the will and the death certificate, they'll release it without a grant of probate. So it's a case of working out what assets there are, finding out the rules for those particular financial institutions, and if you need a grant for one, then you have to value everything in order to apply for the grant. So that's where it gets a little bit tricky and I think misunderstood at times.
Right. Sounds well complicated, doesn't it?
Well, that's presumably what you've got solicitors for, which is why you do all this planning, etc., so you don't get in that situation. Yes? No?
I don't think a grant is something you can really plan for. So I think people try at times.
Yes.
So trying to put properties into people's names in advance of death, etc. Sometimes it works, sometimes it doesn't. It can actually make things worse at times. But I think people look at getting a grant of probate sometimes as quite a scary or a really formal option, but actually it's not that complicated. The process of getting there's a lot of paperwork involved, that's all.
Takes a while, doesn't it, probate?
Not at the moment.
No.
Wow.
I mean, again, it depends upon the value of someone's estate and whether there's going to be inheritance tax paid, because obviously then that can take longer. There's a formal process to go with. But if you have a relatively straightforward estate, then you are looking at we were looking at a lot longer time scales, but it can be a couple of months now.
Well,
can't it?
I've had a lady who died in January and I got the grant on the 3rd of March.
So
There you go.
what just out of interest, because I seem to remember not that long ago, I've read stories in the newspapers or whatever saying probate's taking ages. What's changed? There
was a huge backlog caused by COVID,
Right.
huge backlog, and they were quoting 16 to 20 weeks
Yes.
for any grant to come back, and they were also saying you're not allowed to chase us at all until 16 weeks has passed. So we couldn't even check up where things were just drifting. But now, anything simple, as long as there's a will and everything's, all the T's are crossed and the I's are dotted, we are getting them back once submitted within sometimes days, but most of the time 2 to 3 weeks.
Right.
It's good.
Well
is there
done.
The more complex estates, don't get me wrong, there's a 2-stage process. They do take much longer, but for simple estates,
Is there this probably a daft question, but I specialise in them. Is there is there a lower ceiling? Is it like if it's under 10 grand, it doesn't go to probate, or is it literally from penny one?
So, for instance, National Savings and Investments, so NS&I, their threshold for releasing premium bonds used to be £5,000. So if you had more than that, they would insist on a grant, even if there was not a grant necessary for anything else, and there was no other accounts.
Right.
So each institution literally has its own
So
rules.
there are lower limits, but it just varies all with it.
all over the place.
And it's subject to change as well. So I think when you talked about can you sort of plan your affairs to avoid getting a grant or needing a grant of probate, you can't, because they're changeable. So the rates that the limits that might have been there 2 years ago are different now. So it's a case of when someone passes away, it's approaching all the banks and checking with them really to see what their requirements are.
Murder. Sounds like murder.
Stop mentioning murder.
Well, I shouldn't mention murder. I mean, it sounds murder in terms of very difficult.
It is like an Agatha Christie
It is like
now.
an Agatha Christie, yeah. I'm not saying anybody should murder anybody. I'm saying it sounds very difficult.
Yeah.
There's a lot of paperwork involved, and I
It
think that's
sounds
what
like
overwhelms people a lot of the time,
Yeah. So you need to nail the will as well as...
The clearer the will is, the more straightforward it is, and not necessarily making your assets clear or planning too much, but identifying them, making sure the people who are actually going to be looking after them and sorting them out know where they are, what they are. Because
What goes in a will? Is it anything of value? Is that the idea?
we don't generally tend to specify everything. We sort of have there's a catch-all provision which kind of covers everything, and then if you've got specific wishes, a specific bank account, shares, or a house, etc., you might identify them as a specific gift. But I generally don't go through everything.
You won't put your lawnmower on and stuff like that. Well, hang on,
Unless it's a
your face is saying possibly.
vintage
Yeah,
one,
absolutely.
maybe. Or
A sit-on.
Tractors, personal
Yeah.
possessions are still an asset, so they still can go in there either individually or as a general gift. Absolutely.
Have you got a Gucci lawnmower?
Well, I've got a strimmer. And I don't think either of my kids will want it. It's rubbish.
Should we
But,
turn?
obviously I'm going to think about it. I don't want my strimmer ended up in probate. Yeah.
Things like
Or
that,
the
yeah,
skip.
definitely
No.
don't.
I don't think
so
you need
the
it for
lower
that.
limit is any garden equipment below lawnmower. Got
I think
it.
it's also things that can be physically handed over.
All right.
So,
So you can-
your knickknacks, your clothes, your furniture, anything like that does not require authority from somebody else to take possession of.
Right.
Whereas a house deed or a legal title
Yes.
requires the transfer, and the transfer won't happen unless the land registry have the right document.
Yeah. So it could be the user manual on your lawnmower.
Depends if there's a warranty. It might be the warranties that
He won't have a warranty.
Who fills in the warranties? It's nonsense.
No.
It's just an excuse for them to get your email address off you. That's all that is.
Let's.
Sorry, I've gone off on one there.
Yeah. You're on a flight of fancy, and I'm not sure you bought a ticket. Let's continue with wills. George in HU5, the Avenues area, says, I've written my will on a computer and printed it off. Will people know it's genuinely my will if it isn't handwritten? Do people do their own wills? Do they?
Well, we certainly don't handwrite them. So
No.
ours are definitely
Yeah.
typed.
Yeah. So you do find people doing homemade wills. They do make them.
Are they
But-
legal?
Well, I think the question would be they have to follow, for a will to be valid, you have to follow the legal requirements. So it doesn't need to be handwritten by any means, but obviously it needs to be witnessed. Obviously it needs to be signed and needs to be witnessed by independent witnesses. And so I wouldn't be worried about it being handwritten. I'd be more concerned about whether it followed those requirements, really. And I think that's why seeking professional advice when you're making a will is important, because sometimes homemade wills you can miss key elements within a will, which can actually trigger more complications.
I don't think the fact that it's typed or handwritten is relevant. It's more about what the content of it is.
Yes.
And
It's the witness, isn't it, really?
well, it's not just one witness. You actually
No.
need two independent witnesses who
Yeah.
are present both
Yes.
at the same time that you're present. So essentially 3 people in a room knowing that somebody's signing a will at the same time. So
You said earlier that we should be doing power of attorney like early in our lives.
It's obviously playing on your mind all of a sudden.
Yeah, that's,
It's hit home, hasn't it? It's hit hard.
Working with you has aged me. Just when should we be doing our will?
Well, anyone over the age of 18 can make a will, and I think it's a case of thinking about what assets you have. So if someone owns assets, if they have money in bank accounts, if they have a property, then they should be thinking about looking at their affairs and whether it be relevant. And people have children, you need to consider
So
appointing
presumably you need to
guardians.
update it quite regularly then, or whenever something significant happens.
absolutely,
Yeah.
yeah.
Which is a question we'll come to, and we'll expand on that.
So I think
no, it's not, are people good at doing it? Have they got better at doing it, or is it an afterthought and it's only really happens when you get to the knocking on stage like myself
think
and Dave? Dave less so.
families are used to having
in case he
money.
gets offended.
Very less so.
Yeah, okay.
Families who are used to having assets and regularly in contact with solicitors are quite good about getting the next generation in and introduced and being part of the process from the beginning. So I think lots of people don't even think about it at 18, but if you've got your own money in a bank account and a car at 18, then without a will, it's a complicated process to get access to those because there isn't an obvious person, there isn't somebody who has that authority because you are no longer a child. So the parents don't have the same rights anymore.
An 18-year-old with cars. Dangerous, aren't they? So you need,
I'm not suggesting it was a good idea, I'm just as an example, yeah.
I don't think at 18 though you think about the mess you leave behind, do you? You know.
Well, true. What is the mess you leave behind if you don't have a will? Say you're a normal. I don't know where I was
You've
going.
stumbled already.
Yeah, I'm resorting to cliche here, but you're a couple. You've got a couple of kids, and you've not got a will, and sadly you both pass away. You've not done a will. What mess does it leave behind?
That is entirely dependent on the circumstances for the family, because there isn't a document that tells us what happens, who has authority, so therefore you have to revert to the rules of intestacy, and they set out who has the right to do what, who has the right to get what. And if you've got minor children, unmarried partners, there's all sorts of complications, so it really depends on the circumstances. So being unmarried and living in a house, owning a property, having children is a absolute, you really need to have something in place, because you can leave an absolute devastation behind.
And I think it's the stress for the people that have been left behind. So if you have got that scenario where an unmarried couple with children and the surviving partner, realising that they actually haven't got any entitlement to the estate, perhaps, when they maybe thought there's a misconception that there's a common law marriage, and that isn't the case. And you're going through a grieving period, and then you're realising that actually you haven't got any security to potentially live in the property. What do you deal with the mortgage and everything else? So that's really important to look at putting something in place.
How many listeners do you think we've traumatised so far?
I can traumatise more if you want. Just thinking of the scenario where you're actually married, it's not secure either.
No.
Because there is a sort of set limit that the spouse is entitled to. But if your estate's £1 million, the spouse isn't entitled to it all if you've got children. The children are entitled to some of it. So you might have it all wrapped up in a property or investments or pension pot for the future, and actually all of a sudden your children are entitled to it. And if they're minors, there's nothing you can do about it. They are entitled to it. So having the will can change all of that, because it can get
none of this sorted, mate. None of it.
I can leave you my card.
Leave 2.
It's just made me think I haven't got any of it sorted. Oh, the only row about it at my house is who's getting which picture off the wall.
Well, your will can stop the rows.
Yeah,
absolutely, yeah.
There's certain pictures on the wall that they both want. And I said, you'll have to fight out when I die. I could make a list, couldn't I? 2 witnesses, that'll solve all the arguments.
Is it a Van Gogh or...
I have some valuable... I'm not Ferrens, but I have some valuable artwork in my house. Yeah.
Right.
Not insane.
Right.
The house is worth a lot more.
Okay.
I don't know why I went down that, didn't.
No, that's...
So it just scared you, that's what it is.
Yeah.
I'm petrified. I'm absolutely petrified.
I've just suddenly seen the time. We've been cracking on. Ashley in Gypsyville, quick question. How often should I update my will?
I would recommend every 3 to 5 years without a change of circumstances. Yeah. And if there is a change of circumstances, financial, family, whatever it is, that's another trigger point as well. And it doesn't necessarily mean change it. It just means get it out, review it. Does it still work? If you're not sure, speak to a solicitor, speak to somebody who advised you about it in the first place.
So it needn't cost you any money, you can just be, that's
Absolutely.
fine, carry
exactly,
on.
yeah.
Right.
Particularly getting married as well, a lot of people don't realise that obviously marriage revokes a will unless you've made it in contemplation of that marriage to that person, so...
There's another chunk terrified. Yeah. The brides-to-be.
Yeah, divorce doesn't, but marriage does.
Oh my God.
So there's another... When people get divorced, again, the will isn't invalid, although if they died while still technically married, their partner is entitled to certain things. So that's another reason why.
This podcast's going to cost me a fortune.
Yeah. If they died and forensics discover a frying pan in the back of their head. Divorce. On that happy note, I'm conscious of the time. I think
has anybody got a joke just so we can lighten it up?
It's a difficult subject at times. It's not the easiest, but
I think it's been fascinating.
It has been fascinating. Thank you very much.
So thank you very much for your time, Laura Fahy and Emma Hamilton from Wilkin Chapman Rollits have joined us on this edition of the CuriosityCast. Thank you very much for coming. It has been fascinating and scary at the same time.
Thank you for having me.
Do come back again, because I'm sure there are more questions that we've got. Remember to keep in touch with us via curiosityhull.co.uk or follow and friend us on the socials, where we're Curiosity Hull on all the main feeds. We'll be back very soon with more quality answers to whatever question you'd like to ask.